This is why I always communicate with accountants when I'm doing estate planning. So, a very common thing that I do for my clients that's a huge benefit for them is create an irrevocable trust that is not a separate entity for tax purposes. So, it means that we're keeping their assets within their estate. And this is wonderful because their kids get a step up in basis. They don't pay a capital gains tax if the property appreciates. Also, the parents who are creating these irrevocable trusts are usually in a lower tax bracket. So for income tax purposes, it's taxed to them as well. And I had an incident once where an accountant made a gift tax return to this irrevocable grantor trust. And they shouldn't have, because the goal of this irrevocable trust, one of the goals, is that it's not a separate tax entity. So when you're making the transfer of your property to that trust, you do not file a gift tax return, because the gift tax return means that you've made a completed transfer for tax purposes. And the grantor irrevocable trust is not a completed gift for tax purposes. So that tax return should not have been filed. And we had to figure out a way to make sure that the assets were still includable in that person's taxable estate. So that was a huge blunder that I've seen one person make in their estate planning.